as the speakers in any case know, we had a call for papers, and we had 41 submissions this year, which is more than last year, so we're really growing. For my, where do I have that? Okay, that's in my other notes there. So we had, from the top of my head, we had 13 PhD papers or junior researcher papers accepted, 5 senior researcher papers. So the acceptance rate is lower than 50%. That means that we've been very picky in what to accept and what not. And but given that we have 4 slots, we need to do the math a little. Then with 4 papers in the slot, we have 80 minutes, which is a fair amount for a paper presentation and doing Q&A. But if you have 5 papers in the slot, then it goes down to 15 minutes. We started late already, so that won't work really well. So the idea is to put a little bit into the cocktail reception. There will be plenty of drinks, and trust me, I'm the one who wants to go for drinks at one point. So we'll get to the drinks, but I will also want to give everybody the same opportunity to present their work as in the 4 paper slots. Okay, having said that, so that is one. Oh, by the way, I'm Leenes. I'm the chair of the academic paper session, so but I couldn't do this all by myself. So in total, we have something like 130 reviews for the papers that were submitted by 31 reviewers or so. So many people put a lot of effort in this, and I hope that all the papers will benefit from the comments provided by the reviewers. Okay. Now there's one thing that, due to all the hassle being involved in 4 panels, that I didn't do is talk to all the presenters, so I'm not entirely sure who presents. Although I'm looking around, I think that I know how it will work out. So we'll start first with Napoleon, who, as far as I could find, is a PhD student at the University College London, and also practicing there.
I did finish my law at University College London, but I practice law now in Cyprus.
Okay, good. So now that we have got that out of the way, so that is his background. He will kick off with a presentation on the deep web. So he will define what the deep web is, and also talk about misconceptions there, and also how that provides challenges for data protection regulation. So without further ado, I give you the floor, and I have these cute little signs. So this means 3 minutes left, and this means okay? Good. The floor is yours.
How many minutes do we have?
Let's say 15 minutes, and then 3 minutes for questions.
Thanks. Yeah. Try to be quick, even quicker than 15 minutes. Good evening, everyone. Hopefully, you would ask why do you have another Widely Forgotten presentation since we just finished the Widely Forgotten panel. Well, my effort would be to try to give you a different perspective. I'll try to show how right to be forgotten as part of data protection regulation is linked to what we call deep web. Now, I structure my presentation as follows. First, I'm going to give you an introduction of what we call deep web, and try to give you some terminology and some misconceptions that arise from this terminology, and then I'll try to link deep web with questions of privacy, and then see how deep web causes challenges to data protection, and I'll use 2 particular examples: the household exemption and the right to be forgotten. Now let's start about what deep web is. Well, there's no specific definition that we all accept. However, a more broad definition is that all information that can be accessed via the World Wide Web but cannot be indexed by general purpose search engines. What are the general purpose search engines? These are the ones like Google, like Yahoo, meaning search engines that do not have a specific purpose, they don't have specialized content, they are not addressed to specialized audience. It's a very famous picture where you can see the surface web at the surface, where is basically what the major search engines can see, And then deep web is under the surface, which means World Wide Web content, which, however, is not accessible through Google, Yahoo, etc. Now, deep web, although we see it in the bibliography the last decade, is not actually a new concept. In the past, where there were no search engines, or the search engine's ability was quite limited, basically, in order to access a web page, we either had to know the specific URL, or we had to link to this web page from another web page. However, as the search engines developed and their indexability grew, we replaced our searching skills by actually using search engines to find information on the World Wide Web. So deep web is essentially related conceptually with the invention and the development of search engines. Now, search engines do not index everything in the World Wide Web, as I explained. They have a certain idea on what to search. They have certain algorithms. If they search and index everything, they basically would be impossible for people to find information. So certain information is not accessible through the general purpose search engines. These are dynamic information, for example, or information contained in the private web, where you need to insert a password and enter it to a specific database, or pages that require prior registration, and of course web pages that are contained in what we call anonymizing network, such as the onion router, the so-called Tor. Now, deep web is one term, but it's not the only one. Bibliography pretty much uses interchangeably other mystic type of terms, such as hidden web, invisible web, or dark web or dark net. Dark web is actually even more problematic because it is used for different purposes. First of all, to describe deep web itself as I defined it a few minutes ago. Secondly, it is used as an expression of the dark side, of the so-called dark side of the deep web, which includes basically illegal activities within the deep web, such as drug dealing, child pornography, etc. And thirdly, dark web is used to define anonymizing networks, basically what is inside them. But even more problematic when we discuss deep web is that we have certain misconceptions, which sometimes these misconceptions originate from the terms that are used. So the first problem is that we have the initial impression that deep web is a fixed identifiable area, but it's not. Deep web is basically defined from what the search engine is able to do and is not able to do. So deep web for Google is not the same for what is for Yahoo, because Google doesn't index the same things for Yahoo. The more abilities the search engines have to index information, the lesser the deep web is. The less abilities of the search engines, the bigger the deep web is. What we do know for sure is that deep web, however, is hundreds of times bigger than surface web. Basically, most information on the web is not accessible through general purpose search engines. The second misconception is that deep web is generally not accessible or not easily accessible to the average user. But that's not actually true, although it might be true for information that require privileged access. Basically, when you make a registration on Facebook or you enter a password on a database, you enter deep web, because this information is not within, is not indexed through general purpose search engines. Third, deep web is mainly purposed for unlawful activities. Well, arguably, when information is not easily accessible, this gives rise to interest to actually exercise unlawful activities, since they're not easily accessible. Nevertheless, as I explained, deep web can easily be lawful. Facebook information, information contained in databases of academic journals and libraries are purely lawful information. However, and this is a question to you, could we actually use the general purpose search engine's ability to index information as a criterion in defining what is today considered as deep web? Is this a sufficient criterion? Isn't deep web too large to have a meaning, to consist of a specialized area of knowledge? Perhaps accessing deep web today is not so much a matter of special knowledge. Perhaps basically what we need to do is to know the gateway to this knowledge. So, for example, if you know where the information is contained, if you know, for example, that is contained on the database, the whole point is to enter into this database to find the content that you want afterwards. Now let's try to link what we discussed now with data protection. The first thing I'm going to talk about is household exception. Household exemption is a fundamental general exception to the application of data protection directive. It's basically the idea that that information which is processed in a household and personal perspective, and in this framework, should not be subjected to the rules of data protection. When we put this exception to the digital perspective and to the internet perspective, we are leading ourselves to the so-called Leenes judgment, where the Court of Justice of the European Union basically said that there is no household exemption where the information which is published on the net is made accessible to an indefinite number of people. So basically, when everyone has access to this information, it cannot be considered as a personal processing, personal publication, or household publication. Therefore, this information is subject to data protection regulations. Now the question is, and that's why it's relevant to deep web, is whether searchability of information could be used as a factor in defining whether a piece of information could be considered as part of the household exception. What is searchability? Well, Hajjagog and Struzman say that it's the ability of third parties to quickly and effectively search information through a keyword search. So the question is, how easy is the access to information, or how easy is the search for specific information could be used as a criterion in defining whether information is personal or household, and therefore does not trigger the application of data protection regulations. So the key concept here is, can visibility be used as a criterion in determining the application of data protection regulations? Well, we see three possible specialized questions here. The first one is that information may not appear into the general purpose search engines. Well, this is not so simple, simply because this information may appear in one search engine, but may not appear in the others. But how, again, we define general purpose search engines? Maybe we can use Google, maybe we can use Yahoo, but there are several other search engines who have specialized scope, but is not so definite that could not be used, could not be considered as general purpose. And then again, the question is not whether information appears on a specific search engine. The question is, how visible is this information? Is, for example, a result that appears on the 100th place of a search easily accessible in comparison to the information that appears in the top 10 or in the top 5 of Google's results? Well, in theory, not. And thirdly, could we use the complexity of the search as a criterion in defining the visibility of information? For example, if you type in Google the word John Smith, you'll probably not get the information you're looking for, because there are so many John Smiths that that are enough to hide the information within these results. Having put these questions about the household exception, I turn into the right to be forgotten. I will not describe or define or explain the developments on the right to be forgotten, because most of you probably had the chance to hear the very, very interesting presentations a few minutes ago in Lachaud. So I'll go directly and discuss how the right to be forgotten is related to deep web. Well, when you erase information from search results, we need to understand that this does not erase information from the World Wide Web itself. It just erases links, which means the information is not visible in what we call surface web, but it's still visible in what we call deep web. Secondly, we don't erase the links by exercising right to be forgotten everywhere and from any type of search, but only when we use a specific type of search, which is the name of the person, according to the Google Spain judgment. So we see three types of scenarios. Scenario number one, information is erased from the surface web through the exercise of the right to be forgotten, but still remains within the deep web. Again, kindly note that the right to be forgotten is not exercised in all search engines, but in a specific search engine, which means that information probably remains to the rest of them. Secondly, which means that an effective exercise of the right to be forgotten would require targeting and exercising the right to be forgotten to pretty much all the major general purpose search engines. The second scenario is when information could be erased both from the surface and the deep web. Now, we don't know yet whether the right to be forgotten will be understood as being exercised, for example, in relation to databases or search engines of newspapers or other type of specialized search engines. We know that Google Spain, for example, does not go in relation to the general data protection regulation as far as general data protection regulation, because the general data protection regulation creates an obligation to the search engines to notify third parties for a request for erasure. Therefore, as currently the situation is, a data subject would be required to file a specific and additional request for their information to be erased from each and every specific database. Again, we have problems of anonymity of the website administrators, and we have jurisdictional limitations from the national data protection authorities. And the third scenario, and with this one I'm going to conclude, is that information can be erased only very quickly from deep web, but not from the surface web. And this creates very interesting questions. When we exercise the right to be forgotten in the deep web and we erase information from a search engine of a specific newspaper, does this immediately and automatically lead to an additional obligation of search engines not to link to this website? Because as we know, search engines link to websites information even after the website does no longer have this information. And as a final question to you, how can we exercise the right to be forgotten in anonymizing networks where pretty much the administrators and the data processors of these websites are purely anonymous? Thank you very much for your attention.
Okay, thank you. We have time for some questions. Don't be shy. Okay, shall I? Can you bring up the last slides? Yes. Because to me it seems like there are a couple of interesting sort of seeming paradoxes in there. Maybe go to, I think it's slide 11. Because if you define the deep web as the part of the web that is not indexed by search engines, then basically there is no relation between the search engine and the deep web. And if you apply that to the right to be forgotten, then you got into interesting stuff. Because there is nothing to be deleted from the search engine. So scenario 1 seems problematic from that point of view. But if you look at the other scenarios, so information, scenario 3 raises another thing. Yes, indeed it's the case if you remove, well still you have the issue that there is no link, that basically there's nothing in search engine because there is no relation between deep web and search engine. But suppose that you would delete information from the deep web, then what typically happens in practice that for a while it would remain in the search engine, but because the crawling, at one point Google notices that the information is no longer there and therefore it will be removed from Google automatically. And another thing is, indeed, it is, while Google Spain, of course, is targeted as Google Spain, because that was what the case was about, the ruling, in fact, is more general due to analog reasoning and the fact that it would reappear at the European Court of Justice of the EU anyway if any court would decide otherwise. So it applies to all general search engines. So how do you react?
Well, first of all, in theory, it would apply to Google, first of all. I mean, I'll answer the second point. You said that the right to be forgotten would apply to all search engines.
Yeah.
Well, how will, for example, if a court order relates to two specific parties, well, how would the third party who wasn't subject to specific proceedings be obliged to delete information?
It is common understanding by all search engines that they have to comply with Google Spain. So, yeah, who is implementing it? Bing is implementing it.
But the person has to target its
search engine. No, you're totally right there. That's not harmonized. So you would indeed have to. But that only makes sense because if nothing returns when you search on your own name at Bing, let's say, then there's no point in filing any request to Bing. So you'd have to, there has to be a link with you and what the search engine does.
My impression is that this would lead basically to individuals being innovative in their use of search engines. So basically, we will have a list of 20 or 30 search engines when we would try to, and we would probably search different search engines for the same information because we will probably get different results. And since people would erase information from the major search engines will probably lead into less well-known search engines because these will be less likely to be addressed to apply right to be forgotten. So my impression is that as we go further, we will just start using other search engines that might have more information.
In fact, that would be an interesting side effect that should be applauded because then we're back, then the monopoly of Google is basically broken.
I have one question on a sort of a technical facet. It's also possible to control what search engines store in their database using, for example, mechanisms like robot.txt. And in that sense, it looks like a mixture between the deep web and the surface web, because on one hand, it's accessible, so it can be found, but it's just not, it contains directives that say, just don't put it there. So it's a mixture, and also, if you look at some other, you could call it more specialized search engines, but maybe that doesn't do it justice. Things like FedMap, that basically scans through the whole internet and look for other things. It's just not web pages, it look for whatever you want, but basically browse the whole IPv4 address space, which have been used by researchers for all sorts of different purposes. And I was wondering, you didn't address that, and so I was curious on whether that falls outside this general purpose, but probably depends on the definition of general purpose. But
precisely, the definition of general purpose search engines troubles me a lot, and I realize that there is no widely accepted definition. Perhaps it's an interesting area to work more. Being a lawyer, unfortunately, I wasn't familiar of all the technical abilities of different search engines. So I understand that you're talking about a gray zone where information could be contained partly on the surface web and partly on the deep web.
Yeah,
that would be very interesting.
A publication from the Berlin group from I think last year, the year before, written by the Italian DPA mostly on that one. I think they got it right.
That's very useful. Thank you very much.
Thank you. For time's sake, I would like to stop here, and there is a lesson to be learned here already. Don't let me ask the first question. Too much time. So be creative. Okay, let's thank the first speaker. Now here comes my clumsiness again. I always have problems with Spanish names, what is part that we pronounce or not, but let me try it with García as his name, and he will correct that if I'm wrong there. He wrote a paper together with José del Álamo, who is an assistant professor at the Polytechnical University of Madrid, and you're, I guess, a PhD student at the moment. Okay. Their paper is about, yet again, the right to be forgotten, but then takes a totally different twist. They provide a sort of an alternative for this, rather than taking information down from search engines. He will talk about a mechanism for reputation management, which sort of introduces this idea of countering speech with more speech, if I may summarize it.
Yeah.
But he will give the story proper.
That's a good summary. Thank you very much. So this is a technical implementation of right to reply. It's an alternative to the right to be forgotten. We have developed in a project at Universidad Politécnica de Madrid called Grade 5, together with my colleague José del Álamo, who is sitting there, and who has some problems, because if I look for his name in Google, I find something about scam, and if I say I'm feeling lucky and click here, I find alleged scam by example.com. Someone wants to file a lawsuit for fraud against that company, whose CEO deserves to be jailed, and this is José del Álamo. This was published 1 year ago. I can also like it and share it on Facebook. This is a real problem. It's not a problem he has, fortunately for him, but we encountered a problem with an advisor for this project. Okay, we didn't know what to do with him. This is part of a more general problem, which is called secondary disclosure. This happens when personal information is not disclosed by the data subject themselves, but by other users. This data subject is a respectable man in type, and these disclosures are saying that he's a buffoon, a jester, and the poor man in type is outraged by the information that is being disclosed about him. But also the information consumer doesn't know what to believe. He encounters contradicting information, and he finds also a problem. How is this currently solved? There are 4 major approaches, summarizing. First, if we are dealing with centralized websites where there's a moderator, we can resort to that moderator and ask it for the erasure of the embarrassing or not suitable material. But the problem is that there are sites which do not respond to this model, so we still have that embarrassing information online. There are also some very technical solutions from the state of the art that are based on cryptography and that allow the data subjects to determine who will access any content they disclose. They can establish the policies and other technical mechanisms, but again, we have problems. This only applies to primary disclosed information. We still have the secondary disclosures there happy, and it's also vulnerable to the another gap. So the consumer can just take a picture of the content, and then all the rules cannot be enforced anymore. So if we cannot delete the content, we can at least hide it. So that's what online reputation management businesses do. They propose flooding the web with positive information in the hope that the negative information disappears from search engines or it gets demoted to the second, third pages. But this only hides the information. The information is still there and it can surface again. You can go to the second page, or it can be reached through the deep web, as Napoleon just said, can be shared on social networks, because search engines are not the only way to access information. We cannot hide it, let's kill the messenger. That's what the right to be forgotten proposes. There's a legal obligation on search engines to delete some contents according to specific rules in specific cases upon the request of the data subjects. That, again, we have the problem that the information is still in the original source and can be still reached, and also it does not apply in all the jurisdictions, etc. So we came up with this. What if, when I looked for José del Álamo, I encountered, together with this severe accusation, his reply stating that he has not been involved with that company for 7 years, and details linking maybe to the webpage of the company with the spam, which was the reality with the advisor we met. This is what we have implemented in Verify. This is a screenshot of one of our prototypes targeting social networking services. When the mouse hovers that, well, this cross appears because of Verify, and when the mouse hovers that bubble with the cross, a pop-up appears with posted reply. This is implemented through a set of technical protocols and architectures. I'll go very quickly over them because we are engineers, but I know there's a very mixed audience. So first, we have the disclosers who disclose information, who publish information. Maybe it can be new information. They can republish information that was already there. I think they are retweeting a tweet that was already published. They can also be linking to information that already existed but was not linked to the data subject identity. Let's say tagging them on a Facebook picture. And that information is discovered by the notifier, which is a server. It's part of Verify infrastructure, which discovers those new contents mentioning the data subject. They resolve the identity corresponding to the person mentioned in those contents, and then they contact a guarantor, which is another module, and notify that this new piece of information mentioning the data subject has appeared. The guarantor works on behalf of the data subject. It stores the data subject's replies, so whenever it receives notification, it asks the subject for his or her reply. Okay, so what do you have to say regarding this piece of information? Does the data subject need to provide a reply for each and every information linking to them? No, he doesn't. He can provide general policies, for instance, to acknowledge all the data that is published by some source or in some server. And they can also provide specific ad hoc replies to specific pieces of information. They can also regret for their replies and change it at any later moment. But they do not have to be burdened by the load of replying to each and every time someone says anything about them. So then we have the guarantor, which has already stored the replies, and we have the consumer. Now I'm searching for hosted Álamo, and a third server, a third module intervenes, which is the verifier. It intercepts my request for information, and before presenting it to me, it queries the guarantor for any replies that the data subject may have. So it finally presents the result of the reply it has retrieved. Maybe it can show that pop-up with a reply as we have just presented. It can also filter out any information that is denied or is not acknowledged by the data subject. So I'll go back one moment. The main difference with previous approaches are two. One is that we replace the erasure of the content by the enrichment of the content with more add information, which is the reply by the data subject. And the second is that we replace the charge of the responsibility of implementing that right. We shift it from the disclosures where the information is published to the consumers where the information is consumed, because many times the disclosures are not willing to cooperate. This is how we do that, but who is going to pay for that? Is there any value? Okay, we provide value to both parties. To data subjects who would be willing to pay, or just with monetary value, with monetary goods or any other kind of goods, they would be willing to pay for the monitoring and control services that apply to the personal information that is online about them, but we also provide value to the consumers, which now receive endorsed information. And there are business models where this is already working. For instance, in your equipment, recruiters are paying to get endorsed information about job applicants, and job applicants in turn are paying to make their resumes more visible. It also happens in e-dating services, mostly in those that are targeting matchmaking services, targeting long-term relationships, that date seekers are paying more to get more information and truthful information, trustworthy information. But there are also other more complex models that can be applied. For instance, Google could implement this and could benefit from this by including notifiers in the services where they are hosting content, such as YouTube, Blogger, Google+, including verifiers as plugins to the browser, Chrome browser or the Android browser, and provided the guarantor as their own service. Or they could, also using existing services, integrate notifiers with Google Alerts, which is a service that notifies you whenever a term appears in a new content on the internet, and is already used in a service by Google called Me on the Web. Don't know if you know about it. It notifies you whenever new content appears about you on the web. Then the guarantor could be integrated with Google Dashboard, which currently allows you to control the personal information that Google stores about you. It could be well extended to deal also with this kind of personal information. And the verifier could be integrated with the search engine algorithm, so that the algorithm could take into account as another input the replies from the affected users. Okay, so this is the summary of the business model. As a conclusion, this is not a one-size-fits-all solution, because we have the right of reply could be the only solution in some situations when we cannot control the source, we cannot control the channel, where there are different jurisdictions where the right to be forgotten does not apply, where there are conflicting rights that prevent the right to be forgotten from being applied because of journalistic, historical interest, public interest, etc. And also, on the other hand, the right to be forgotten could be the only solution when there are embarrassing or dishonorable stories, or maybe when there are images depicting the data subject where you cannot say, no, this is not me. Or you could, because this is an image from last week. It's Gérard Depardieu, a French actor, who is holding a sign saying "Je suis Charlie," supporting the journalist from Charlie Hebdo who had suffered terrorist attacks. But this has been manipulated, and in the other image he says, "I'm drunk." And this went viral, and it was considered as real and was more famous than the original image. So maybe it could just provide a reply linking to the original image, saying, no, it's not me. Think also in mugshots that are published of people who are eventually released as innocent. The mugshot is there, but they can reply, okay, this is the result of the trial, or I was not even trial. So thank you very much. That's all for the presentation.
Okay, well done and within time. So a couple of questions. Let me start there.
So how do you solve the John Smith problem, which is that there are lots of people with similar identifiers who are not, you know. So I write John Smith as
Yeah.
and do all John Smiths get notified, or none of them? And who has the right to then kind of come back on that?
Yeah, there are, let's say, three main approaches for that. First, John Smith can be not only John Smith, but specific John Smith in many contexts where the information is semantically notated. For instance, in social networks, you are not John Doe, you are at John Doe, which is, I'm thinking of Twitter, for instance, which is only a single identity. That's the basic part. Then there are mechanisms which were not developed by us, which are called identity resolution technologies, which try to match an individual, or let's say a definition of an individual, with a specific identity. They do not work always, but then the third part comes. If I look for hosted Álamo, this is a real example now, I encounter several people who are called hosted Álamo. I, as an information consumer, what I perceive is that hosted Álamo has done many things. I cannot distinguish among these different hosted Álamo. So this can be taken advantage of, and hosted Álamo can just mark this, and this. It's me, and this is just, I just do not reply to them or do not acknowledge them. Because, as I said, there are policies so that you don't need to reply to each and every. How I answer?
But that means that you learn a lot about your namesakes. And John Smith will have an enormous task of going through all of that. I won't, by the way. There's only one of you. First lady in the back, and then Ivan.
With this solution, if you look at the business model, does it not just mean that you create a divide where only people with money have the right to sort of reply, and people who don't have money, you know, we just believe everything we read about them because there is no reply, therefore it must be true.
Yeah, I understand that. That's just a business model proposition. Okay, so no, it's yeah. If we take the value network, this is agnostic. We are not proposing that they pay us. As I said, it does not to be monetary goods. If we go to these models, equipment and dating, they are already working. But if we go to the Google model, you do not see any monetary flows here. We propose that people can apply the right to be forgotten when they want to do that, but maybe sometimes it's more effective that they apply the right of reply that is already applied in the journalism arena. So that maybe Google can also be interested in enriching the information with more information, which is their business model, without necessarily implying that the data subject need to pay for those replies being indexed. So I'm not vouching for users paying for making their information being erased, which is what reputation management companies do. But just that this model has a balance so that it works and it provides value to all the parties involved, because otherwise they would not have the necessary incentives.
Yes, the false and misleading information, the fate of this information is clear. You can have a right to reply. But what if the data subject has absolutely true, correct, but disturbing information about him or herself? That's the first question. Can you filter it out? He verifies himself or herself and wants to filter it out. It's not misleading, not incorrect, it's correct. Second thing, what if the verified data subject would quote new, false, misleading information on behalf of his own real identity? How can you...
Great question. We are working in some econometric models for that, because you need to believe this, because there are some sort of formulas and graphs, and they are not in this paper, that the data subjects are disincentivized to provide false information. It's not the ultimate solution, but they are disincentivized to provide false information, because if someone knows that, and this someone can be also an algorithm, that that data subject is always a liar and is always providing false information about them, then you, let's say, just need to take the opposite of what they say to get the truth. As I said, there are some others, so they are disincentivized to do that. On the other hand, we do not say that the information is true or false. We say they are providing the replies. This morning, I found a case that I prevented from using as an example here, which was from a person who told me that had been subject to revenge pornography. But when looking for information, you met both sides of the story. The person who had been accused had been eventually declared innocent, and you got both sides of the story. I'm not leaning towards any of them, but I just got the replies, and then I can make my own judgments. So maybe it was not a false accusation, but I can get the full story.
Yeah, there are two things, and I would first want to have the questions before giving you the floor for an answer, and that's one for you over there.
Thank you. So actually my question is also a bit building up on Ivan's remark, because so I think that your presentation is very interesting, so thank you very much, but I think there's, I mean, one should keep in mind that the right to be forgotten is based actually on the right to object, which actually it's it's linked to Article 7 of the directive, which is about the legitimate grounds for processing. And it's different than the right to access or erase or rectify, so Article 12 of the directive, which is about the accuracy and the quality of the information. So when you talk about the right to forget, it's really about the fact that the processing as such is illegitimate and should not take place, and this is irrespective of the quality of the data. And so I think it's kind of a bit misleading when you present things in this way.
Yeah, I understand that. As I'm not a lawyer, as I said, so sometimes I do not use precise terms, although I'm familiar with the DPD. But the point is that this is a technical alternative. So what I want to say is the right to be forgotten is there, and that's a right. We do not, never, in any case, propose the right to be forgotten to be removed. No, that's a right. But there's also a right of reply in the realm of the journalism. And following on this idea, maybe in some cases the users could take advantage of that idea to provide, to have a technically feasible means more efficient and more effective to reach their goals of protecting their privacy and reputation.
So very quickly, if we understand it right, you're not proposing a right to reply as an alternative to the right to be forgotten.
It was the title.
Or substitute, so it's something additional, something a different privilege.
That's it.
Okay, because I mean the question is, what if there is no reply? What if you're just embarrassed of the information and you want it out? What if you don't want to reply, but you just want it out? Then you would say we have the right to be forgotten, which is another story.
Yeah, that's another story.
Well, that solves it, resolves it. Okay. Thank you very much. Somehow every presentation provides an interesting challenge for me. I know Matthias because he was on my panel last year, but I don't recall his background exactly, and I only have the anonymous papers in front of me. I did find Marijn's information online, so and I was expecting that Marijn the presentation. She's a PhD student at Amsterdam, but given the fact that Matthias is also behind the table, this will be some sort of joint stage or.
It will be an interoperable.
Yeah. Okay. So
there was a lot of confusion up front. That's true.
Yeah. Okay. So I'm not the only one. Oh, wow.
Yeah.
Okay.
Do you want to sit there?
I don't know. If you could just operate the slides.
Yeah.
Okay, so we're complicating things further. Anybody in the audience who wants to give wants to lend a hand here as well? Okay, so no, we're now moving to totally different territory. We will be talking about Foucault and surveillance and security industry and things. So we'll let them do the talking. Okay, Marijn, I think you're ready to kick off.
Yeah, thanks. Yeah, so we'll do indeed an integrated discussion. I will start. Next slide, please. Okay, so these are just two quotes that me and Matthias often encounter in our research. So the first is, this time has come to harness and develop common tools and policies to tackle common threats and risks using a more integrated approach. The other one is, Europe represents the world's most dense interoperability challenge. Oh, sorry.
Sorry,
so to just give some brief backgrounds on what we're doing. My research is mostly on emerging new security markets. So I look at new technology providers called civil security providers that provide new sorts of technology for today's new threats such as terrorism and large-scale disasters. Matthias, I think, has similar expertise, but additional to that, he also researches more on data protection, data integration, etc. And so in both our research, we encountered this notion of interoperability, and it was one that puzzled us. What does it mean to talk about interoperability or interoperable security, or associated notions of integration, seamless integration, cooperation, or plug and play? What does the interoperability challenge that we find here actually mean, and what are the effects of interoperability? And how can we understand this focus on interoperability and integration? Hi. You may come in, or not. And like other concepts in EU security, such as resilience, it seems that interoperability is a very broad term. It encompasses a lot of different things. But mostly it refers to common data, common information, or common knowledge. We also find that extraction seems to derive precisely from its broadness. So we may also argue that this is a sort of buzzword, or it's become a sort of buzzword. At the same time, we don't think that this is a very satisfactory answer to the question, how can we think about interoperability and where does it come from? And so to draw out some of the specifics of this concept, we propose to write a genealogy of interoperability in order to, as two scholars in our fields wrote, historicize features of the otherwise timeless and necessary present. So following Michel Foucault's work, this means that we try to examine interoperability as a result of temporally and spatially specific problem constellations. And in particular, what we argue is that we find that interoperability refers to a particular form of integration. That is, interoperability puts forward a form of integration that continues to allow for a certain level of sovereignty and autonomy for national governments, for security agencies, and for systems operators, who often remain reluctant to fully integrate their research or their resources in other institutions. So how did we develop this argument, and where does this genealogy start? So here we come to the next slide. And this is a bit of something that I'm obsessed with. So our examination of interoperability begins in the military domain, and in particular in relation to NATO and NATO enlargement after the Cold War. And next slide, please. Here we have, oh, this is an old slide, but it's fine. Here we, on the left top, we have a quote from General Klaus Neumann, who was then chairman of the North Atlantic Military Committee, who wrote that with the experience gained through the integration of non-NATO forces into the IFOR operations in Bosnia, and as NATO nears decision on enlargement, it is perhaps timely to look at how we're moving from cooperation to interoperability between NATO and partner countries. So in some ways, we could say that it seems that interoperability is something more than sole cooperation. And the concept of interoperability specifically was introduced to strengthen the ability of NATO and partner countries to undertake joint missions in the context of the war in Bosnia in the 1990s. And while for Neumann, cooperation referred to the exchange of expertise in the realm of defense planning and military strategy, the notion of interoperability was supposed to do something more. It was introduced to strengthen the idea or the possibility of multinational operations. And crucially, interoperability of NATO's member forces involved a sort of blend of national and allied command. So for the most part, member forces would actually remain under full national command. But for some circumstances, NATO members would assign specific forces under the operational command and control of NATO. And this meant that NATO could exercise joint planning, joint training, joint exercises at regular periods. And it was in this way that seamless interoperability was supposed to be achieved. So this is where the idea, partly the idea, our idea comes from, that interoperability is a sort of blend of integration, but still the maintenance of sovereignty. So we'll go to the next slide. So very shortly then, before I let Matthias take it up and bring it to a more current discussion about data integration, interoperability had actually long been on the NATO agenda. We could say that it was actually interoperability that formed the basis of NATO cooperation. But it had become more persistent in relation to two developments. The first was the idea that the world had become more diffuse and more complex and less predictable after the end of the Cold War. And in this context, interoperability was articulated as an answer to a global threat environment. And second, from a US perspective in particular, interoperability, or the pooling of capabilities, was also seen as an answer to decreasing defense budgets in Europe. So it was supposed to be an answer to the so-called capabilities gap that was haunting NATO in the 1990s. At the same time, and that's the third theme here, we see that the capacity to interoperate or to be interoperable also differed among or across NATO partners and NATO countries. And this created what we may call an interoperability gap. And this was particularly the case in relation to the new areas of intelligence, reconnaissance, and surveillance. that we see emerging also in the 1990s. And in this domain, interoperability emerged as a concept to ensure the exchange of information, the exchange of awareness, and the creation of situational awareness, or so-called operating pictures. Then the fourth and last theme that we also see in these discussions, these military discussions, is that interoperability also emerges in relation to what we may call systems thinking. And we suggest that at the specific level of technology, it is in the broader context of systems thinking that interoperability emerged as a crucial concept. And the idea here is that interoperability enables systems to interact with other systems, forming a larger functional unit. Again, this is a particular mode of integration, one that allows for system of systems architecture, and for so-called plug and play. This is a form of integration as part of which diffuse systems or different systems continue to coexist. Yet these systems are rendered interoperable through a process of streamlining interfaces, capabilities, organization, communication systems, etc. So we've identified 4 different themes that we also find in today's discussion in what we may call civil security, and this is something that Matthias is now going to talk about.
Right, so thanks a lot for setting the stage. In the time we have left, I will try to show you how the principles of interoperability have more recently been translated to the realm of civil security in the EU. And by civil security, as Marijn has already mentioned, we predominantly mean the focus on security-related databases in the area of justice and home affairs. I think it should generally be emphasized that before interoperability was highlighted in terms of security, there had already been attempts in the late 1990s to create an interoperable European high-speed train system, for instance, with facilitated cross-border services. And also more broadly and more recently, the European Union has put emphasis on what they call a European interoperable framework that seeks to harmonize and integrate all kinds of activities and services. So I suppose one might even argue that the EU as a whole is in fact nothing but a project of enhanced interoperability in terms of markets and more generally in terms of government. And I think that in this we already find reflected the first theme of interoperability that we identify in the paper, which is interoperability as a response to economic pressures, not only in security but more cross-cutting throughout many policy areas. If we can skip to the next slide. Right, and so let's go back to security. The internal security strategy of 2010 has quite prominently identified the threats that the EU is faced with today. And these are, quote, terrorism, a serious and organized crime, drug trafficking, cybercrime, trafficking in human beings, sexual exploitation of minors and child pornography, economic crime and corruption, trafficking in arms, and cross-border crime, end quote. The Stockholm program, which is the working program for the Justice and Home Affairs area for 2010 to 2014, in this sense states that, quote, natural and man-made disasters such as forest fires, earthquakes, floods and storms, as well as terrorist attacks increasingly affect the safety and security of citizens and call for further development of union action in disaster management, end quote. So, in other words, the world has become even more complex and difficult to deal with, right? So here we find the second theme of interoperability, which we define as increasing complexity and unprecedented threats. Which brings us then to the third theme, the need for information sharing and improved situational awareness. And I think this is probably the most interesting one for the CPDP context. The S-Group report, which stands for European Security Innovation and Research Forum or something, that has been quite the landmark in identifying security needs in the EU back in 2009, has laid out that there was a dire need to render European security systems more interoperable, and more specifically, it has highlighted the need to make databases integrated water protection framework, and subsequently both those areas have been pushed since then. And within the internal security strategy, the need to, quote, exploit the potential synergies that exist in the areas of law enforcement cooperation, integrated border management and criminal justice system, end quote, have then been institutionalized. And in fact, if we look at the current landscape of presumably interoperable databases, there is also much discussed systems such as the Schengen Information System, the Visa Information System. We have Eurodac, we have the passenger name record agreement, we have advanced passenger information, and so on. And of course, we have also many agencies that have access rights to them in one or another form. And this has in turn, of course, been the subject of data collection and privacy interventions. So think, for instance, of the principle of purpose limitation, the right to redress or the right to be forgotten. If we could skip to the last slide. Okay, so now, of course, we are all aware of the presumed conflict between security and privacy. Even this is, of course, a reductionist dichotomy. And in terms of data protection, national security is a reason to put an override on many regulations. However, on the other hand, as we have pointed out, data exchange and coordination of police work and also judicial cooperation
5 minutes, please.
Thanks. Between EU member states have become major principles in justice and home affairs, right? So the treat of interoperability is then arguably that it does not seek to pool data, but to leave it within its original context for which it had been gathered in the first place. So instead of merging existing databases, interoperability then seeks to render the interfaces compatible such that information can be exchanged nonetheless, however without challenging institutional autonomy, sovereignty, internal organizational structures, and so on. And also arguably without generating conflicts in terms of data protection law. So at least this is the impression that one gets when we're looking at EU policy documents and the constant calls to enhance information exchange and interoperability. So to conclude this, I guess from a data protection perspective, as the godfather of CPDP, Paul Hert, has highlighted many times, there is indeed a need to address legal gaps in terms of a framework that regulates interoperability questions, for example, in terms of data processing and exchange. Thanks.
Okay, we have time for one small question.
Okay, so interesting approach that you've taken, like starting with data and I come from an engineering background, then I work on interoperability, working on standards for it was a and I think there are a couple of interesting activities. For example, projects such as information sharing for security. There's some standardization efforts in that space to specifically deal with the format of these messages that are passed between different agencies. And also, beyond the standards, actually, on the procedural, you can also have accomplished write standards that address organizational and procedural aspects that are being worked on. There's activities not only within Europe, but also in the US and NIST.
Thanks. I'm going to take this as a comment.
And I'm not taking this as a question, but I suggest that the three of you get to meet at a cocktail thing. Which, as people will have realized, this was the 5-minute now, we still have 2 presentations, so this means another half an hour in any case. So while we change the presentation, thanks to the speakers, of course. While we change the presentations, we want to, well, it's not a shameless plug, everybody benefits from this. I want to point out that in September we will be running the I think 8th or 9th IFID summer school on privacy and identity management. There is a call for papers open. Go to ifid-summerschool.org. You'll find all the details there. Submit papers, come to Edinburgh, and meet some of these people here and me in any case. Okay. Next speaker is Lachaud. He is a PhD student at Tilburg University. Even more so, he's one of my PhD students, but that's totally coincidental. Eric will talk about standardization, no, not standardization on certification, but it's related. So we'll see where that gets. Okay, Eric.
Thank you. All right, my name is Lachaud. I am an amazingly external PhD candidate, and at the same time, I am a senior IT consultant. And my research with Ronald, thank you for your patience, Ronald, is focused, of course, on certification and the possible contribution to certification in data protection. That's why I'm here today to try to present you a proposal with all idea, all process was in force in Europe for 30 years now, and make a proposal to use this, to reuse this process to enforce privacy by design in the connected devices involved in IoT. First, I would like to define the scope and the term of the subject to be sure we all agree about what we are talking about, and then to present a little bit more my proposal and to assess the benefits and the limits of this proposal, and then to see if this proposal, whether this proposal is relevant or not, because it might be a false idea, and see with you to finish and to conclude about the possible alternative, what could be done with something like this. First, when we are talking about privacy by design, of course I'm talking about privacy by design in the proposed GDPR, and you see the two things has to be highlighted. This is a general requirement for controller to implement appropriate and proportionate technical and organizational measures, states the Article 33, and you can find this provision in all the versions of the GDPR. And you see, especially in the European Parliament version, this is privacy by design is a full scope requirement which could be applicable in services and products, and within the entire life cycle of the technology, it will be a requirement very complete for the control. Secondly, when we are talking about the Internet of Things, this is, I think, a package. When you are talking about Internet of Things, this is dual because you have at the same time a full array of connected devices when you are talking about Internet of Things with this capability to collect and to transfer data each other or with a third-party system. And you have at the same time a communication infrastructure which is set to exchange this collected data most of the time with third-party systems. And you have, of course, both when you are talking about the IoT. Here is the scope of my proposal. I want to limit my proposal and exclude the communication side of the IoT because the compliance of communication infrastructure must be addressed independently. This is a tricky issue, especially when we are talking about the cloud computing. And here I want to focus only on the compliance of building system into the device connected to the IoT. Then, when you are talking with the core subject about the CE marking process, I think most of you were not born when it was set up, but I was young, I have some hair in my head, and it was a nightmare for us. I was a young student in law with the Cassis of Dijon case. When we have to talk about the CE marking process, I think there is three main things to remind. First, it's a conformity assessment process, which has been set in mid-80s to ensure the conformity of products with European regulation, especially on health and safety. Secondly, the process is integrating in what has been called the new approach policy, which has been set by European Commission in order to accelerate at this moment the technical harmonization between the member states and achieve quickly, because they were late, the single market on time. We were in 1985. And finally, and this is the most interesting, I think, this is an original regulatory arrangement which is involving a lot of stakeholders, which has the European legislator, the standardization bodies, the manufacturer, and the private conformity assessment body who are here to assess, of course. I'm going to explain you quickly how the CE marking process is working. You have at the top left of my chart the European legislator who is issuing into the directive, which is so-called new approach directive, the essential requirement. The essential requirement is essential requirement in design and also for the type of assessment the manufacturer or the accredited conformity assessment body has to do on the product. The European legislator sets the essential requirement, and then he asks to the European standardization bodies to do a job to detail this requirement in standards. These standards become harmonized when they are replacing all the standards, or the same standard existing in the library of the member states. And you have only one standard in all member states, and then you have an harmonized standard. Then, depending on the requirements set into the new approach directive, or the manufacturer is able, because you have a low risk product, is able to self-assess and to self-declare its conformity with the harmonized standards, or depending on the higher risk of the product, he has to use the services of what the Commission called a notified body, which is an accredited assessment body, who is going to assess, of course, and attest the conformity with the harmonized standards. At this level, the manufacturer or self-declares its conformity or declares the conformity with the attestation of the notified body. This allows the manufacturer to affix what you saw on the chart, on the bottom of the chart, which is the CE mark on the product, which allows this manufacturer to market this product in every member state without any more procedure. And of course, at the end, the national authority is ensuring a permanent monitoring of this product on the market and has the right to withdraw this kind of product if they are no more compliant with the harmonized standards. All right? Then, my proposal is to use the CE marking process to enforce, as I told you just before, in devices involved in the Internet of Things. What does that mean? It means to include this PBD requirement in new approach directive, to say, okay, we have existing directive, it could be possible to include it, include new requirements. It could be possible to apply the assessment requirement according to the level of risk of these connected devices, and to mandate European standardization bodies to include this new PBD requirement in the existing European standard or in new standards. Of course, we would have to accredit conformity assessment body competent to allow compliant manufacturer to affix this marking and to market their product in all member states. And then the last proposal is to entrust national GPAs to monitor the market of these connected devices. You say, okay, this is a proposal, and tell us why you have such a proposal. But I have such a proposal because, as you see, as you know, as you heard, there is a quick development of the connected devices, of course. This is not a good news. 20 billion in 2025. I don't know the number, but this is exponential and it's growing very fast. Most of the devices today are designed and manufactured outside Europe. And data protection regulation for products remain particularly unclear about the product. When you are looking into the next regulation, proposed regulation, there is nothing very clear on the regulation of product. The BBD principle sounds the most suited for the regulation of product. I wanted to say here that this is a performance requirement, and this is more applicable for products. And this is an ex-ante regulation because you are applying by default some principle during the design phase of your product, and it will be more suitable for large series of products, of course. And then accountability instruments set in the draft GDPR does not really address compliance of products. Just a quick example of Article 39, which is so far very general and does not offer at this level some solution, for products. The benefit quickly of this proposal is to say, okay, we are looking for regulation, and in this proposal could be an example of co-regulation because it encompasses a lot of different stakeholders and offer to make the job and to cooperate between the legislator, between the standardization bodies, and between the conformity assessment process. We have the synergy because, well, I have to go quickly. Well, I think it's important to say, okay, there is cooperation. There is also another important fact, which is accountability, because you can, with it, have documentation. There is a powerful incentive in it, because with this mark, you are able to market your product in all the member states. You are based on a risk-based approach, self-certification for low risk, third-party certification for high risk. Of course, you are able to spread your approach, because when you are making some standard, of course, it applies outside of Europe, and it will be very great to widespread our approach. But there is a lot of limits, of course, about this approach. I'm not going to detail, but you are, of course, in the relevancy of seal policy, because when you are in a nanotechnology, it's difficult to see a seal. This is unreliable because everybody knows that the seal marking lack of monitoring. This is also misleading because sometimes it's a self, sometimes it's third-party certification. And then there is a legal uncertainty about the seal marking who has not really a legal status and has no legal value. This is a seducing proposal, I think, because it addresses an important issue, but the inclusion of data protection requirements could create more confusion, and I'm not sure this is workable as such. But I think there is a possible alternative to use the CE mark as another arching certification mark, and not to include the requirements, the PBD requirement, into the existing CE marking. It will be maybe a solution to create and to design a data protection CE mark. I think it will be a powerful incentive for manufacturers to comply, because if you are able to market everywhere, I think it's very interesting for the manufacturer. And to finish, I would like to say it will complete data protection harmonization, because it's going to harmonize the sub-regulation. If you are harmonizing the legal regulation, you are not always harmonizing the sub-regulation in standard. And if you want to do this, I think it will be very useful. To conclude, I'm sure this is not one size fits all solution, but I'm pretty sure this is a workable solution that already exists and everybody on the market knows very well for 30 years now. I think it's a transitional solution that could be useful for a problem for which we haven't any solution today, and it needs, of course, more investigation to define the design of this data protection schema. Thank you.
We have time for one question. Just one comment.
There's a paper from Leese about.
I saw it. Yeah, Daniel Lemetre was involved in it. Yeah. I saw it.
It was written in response to some of the earlier drafts of the European regulation. So it might provide some interesting insights in some of the trade-offs, because there was some cost associated with it. So there's of course details that have to be worked out on what specifically would be subject to the certification process, which is the crucial aspect of the thing.
Yeah. So maybe that is something that you can try and work out.
Yeah.
Friends.
Two friends.
Okay, so there's always a final speaker, and I know all position is in a lineup, but we have a great speech, I think. So this is a team of researchers composed of some people from trilateral research, but also the godfather of the CPDP, who is now trying to hide in the back, and the researcher within his group. So without further ado, Rowena, the floor is yours.
Thank you, Ronald. Yeah, first of all, I'd like to say that it's a privilege to be here, and I think just because it's an academic panel, I don't think it's any less important, because I think there's quite some very interesting stuff that's been said here today, and I know we share some commonalities in terms of the work we do and what I'm going to speak about. So it's been a pleasure listening to the last 3 sessions, and I promise to be brief. I'd like to just introduce my 2 co-authors who are here. Of course, the godfather of CPDP, Paul, and David Barnard-Willis from Trilateral Research, who was instrumental in kind of making me the public face of this presentation. So thank you. And I'd also like to acknowledge the other co-author, who is Vagelis Papakonstantinou. I hope I've got that right, otherwise Vagelis is not going to forgive me for that.
That's a great guy. Good advice.
Okay, so the basis of this research that I will just be presenting a few findings to you here, and this was a study on EU privacy seals commissioned by the Institute for the Protection and Security of the Citizen, DGJRC, in connection with DG Justice, because since 2007 there has been these policy aspirations expressed for privacy seals, and I think this is not very obvious to people who suddenly think this has popped up in the regulation in terms of why is the regulation talking about certification. So if you need to know more about the history of why the Commission and other stakeholders are talking about privacy seals as being good mechanisms of ensuring compliance, we can discuss that in the cocktails as well, and if we have time. So the study was coordinated by Trilateral Research, and we had 2 very good partners involved with us, Pre-University Brussels and Intersoft International. It's just concluded in July, and the objectives were to analyze the scientific and organizational success factors of an EU-wide privacy certification scheme, to assess what would be the roles of different stakeholders, to look at different case studies that would help us understand whether this would work in different sectors, what kind of criteria would be involved, and its impact on legislation. Now, the problem during the study that we encountered was the Commission came out with a proposal. Subsequent to that, we had the Parliament version of the proposal that was adopted in March, and mainly I will focus on what is in that. So when we did the study, we found out several things about the existing privacy seal scenarios. So we looked at 25 schemes that had been identified. Some of them were not specifically privacy certification schemes, but kind of had privacy incorporated as maybe a marketing element, but something that's sold. So we find that it's far from optimal. So the current privacy seal scenario is highly self-regulatory, and we see that there are various problems and flaws in the existing sector. So we have schemes that have a close relationship with their members driven by commercial profit and bias. We have various counterfeit seals that have security flaws. We see that some of these schemes have a very inefficient evaluation and certification process. Some of them are very flippant in terms of what they certify. They have very weak privacy and data protection guarantees. Some of them have very inactive elements, so they have a front that they put up, and some of them even have out-of-date websites. They have no complaints mechanisms. We have in fact tried to email some of the schemes, and we've not got any reply from some of them, despite their promising to be very transparent and open in their practices. Even some of the prominent schemes were very not so forthcoming with the data. As we said, many of them have very poorly accessible policy and contact details. I think you're all aware of the fact that Trustee has kind of, the whole scandal about Trustee being prosecuted by the FTC has brought this again into the spotlight. And I think it's quite important because Trustee was one of the schemes that we examined. And it was prosecuted for two reasons. One was that it did not conduct its annual recertifications despite saying that it annually recertified its members. And the second thing was that it had misrepresented itself as a not-for-profit company when it is in fact now a for-profit company. Now, we also looked at the 25 schemes that we analyzed in terms of whether they fulfilled what were at the time elements that were incorporated into the Commission's version of the regulation, and we find that the requirements are not very well supported by existing privacy seals. The schemes that are based in the EU seem to approximate some of the elements quite well or fairly well, and these are elements of the commonly accepted data protection principles. So these principles are expressed. I'm not saying they are completely taken into account because that wasn't very evident, and the data protection regulation provisions, some of them are less relevant to the schemes that are based outside the EU. And from the analysis of the 28 elements that we pulled out of the data protection regulation, we see that many of them are not prepared or do not kind of require the members to have any provisions on data protection impact assessments or the principle of accountability or any accountability measures. And none of them, I think, had any provisions on protection for minors. No schemes analyzed also had an explicit requirement for certified entities to adopt data protection by design and default. And what we see is, based on the study that we conducted, is that schemes, once the regulation is in place, will probably take on both the elements that the regulation will put into place. So I think it's very important, and I think having a legal background, to have a legal slide in my presentation. So I think we have in the other panels as well, certification has been mentioned, but I think we need to look at what the data protection regulation says about certification mechanisms, even if this is all I have time to do. So I've tried to make it as simple as possible. So what the basis for Article 39, which everybody speaks about, is Recital 77, which we need to know about. So what does Recital 77 say? It says that there is a need to encourage the establishment of certification mechanisms, data protection seals, and standardized marks. The reason I've reproduced the text is in no way does it limit the scope of what can be done. Why? The purpose behind encouraging certification mechanisms is to enhance transparency and compliance with the regulation and to allow data subjects, that is individuals, to quickly, reliably, and verifiably assess the level of data protection of relevant products and services. Very good objectives, and you can see the basis for this rationale. So it also says further that a European data protection seal should be created to create trust among data subjects, legal certainty for controllers, and at the same time to export European data protection standards by allowing non-European companies to more easily enter European markets by being certified. So there is, again, they expressed a very good need. So in all, I think Recital 77 captures very well some of the needs and findings that we have found. And further, I've got Article 39, what Article 39 says. Now this is from the data protection regulation that was, the version of the regulation that was adopted by Parliament. I'm not going to comment anything about the lead council text. So in Article 39, you can see, Article 39 says that controllers and processors could request any supervisory authority in the union for a reasonable fee, taking into account administrative costs, to certify that the processing of personal data is in compliance with this, is performed in compliance with regulation. In particular, Article 5, which is the data protection principles, Article 23, which is data protection by design and default, am I right, Paul? And Article 30, which is the security of processing requirement. And further it says it also has to be in accordance with the obligations of the controller and the processor and data subject rights. So in all, very ambitious aims here. From the study that we conducted, the study had 4 tasks. In the first task, we had this inventory and analysis of privacy certification schemes. In the second task, we looked at established EU-wide certification schemes, and one of the schemes we analyzed was the CE marking, because that is an established model, and as you say, it has been established for a long time, and it has its advantages, it has its disadvantages. So we've documented why we think it might be a good idea to have something like that. So we learned some lessons from how the CE marking works and does not work. And in the third task, we looked at different case studies on CCTV, biometrics, smart metering, and cloud computing, which helped us understand further what, if at all, are the priorities of an EU privacy CS scheme. So these are the ones that are summarized on the slide here. So we don't want a repetition of what already exists. We have an N number of privacy CS schemes. What we want for the EU privacy CS scheme is an appropriate level of privacy and data protection for individuals. It needs to enhance the internal market dimension. It needs to promote a harmonized approach across the EU. The scheme needs to be specific and can have detailed guidance. It needs to promote public trust and awareness, otherwise there is no point to it. It needs to be flexible and adaptable across sectors, transparent and accountable, and sustainable. So in all, there are certain important things that it needs to take into account. And further, there are even more based on all these learnings. It's not as simple as saying let's set up an EU-wide scheme that here's the priorities, but there's also certain other things that it has to do. So it has to recognize and understand that there will be certain obstacles and challenges at the EU and national level. For example, for instance, in the CCTV case study, we see that CCTV is largely a nationally regulated subject. It proves, it just goes to show you that what would be you need to determine what would be the value of having a European seal, data protection seal at that level. Now, it should also, EU privacy seal scheme should also embody the key requirements that are essential features of other EU sectoral certification schemes, for example, the CE marking. The scheme should be clear, transparent, with clear objectives, scopes, and rules of application. It should set a high, meaningful standard. And it should be adaptable to a range of contexts, and as Eric mentioned, it should also have competent market surveillance, because we found that most of the well-known certification schemes have a problem of being counterfeited. Even the Canel label, which had a problem with this, and they had to take action against one of the someone who was counterfeiting their label. And the scheme should finally have methods for keeping itself relevant, updated as best practices develop. I think that's the challenge you also identified. IoT moves so quickly that the scheme would need to take this into account. In the study, we examined 3 options. Happy to talk about not 3 options, rather we examined 6 options. And these are the 3 that we kind of highlighted in the paper as being the most promising options. And in fact, one of the options was incorporation of EU data protection requirements into an existing scheme, like the CE marking. You can read more about that in the final report of the study. All the deliverables are available on the EU bookshop, sorry, excuse me. And finally, I will just conclude now, because I'd like to take questions if possible. The recommendations that we made can be summarized into these 4. Is that the option should not in any way limit the rights of data subjects or enable certified organizations in any way to adopt dubious practices, because that's what we've seen has been happening. Whatever the option or scheme that is chosen and adopted, it should be rigorously applied and promote a harmonized standard across the EU, because this is what we are missing at the moment. The objectives and scope of the scheme should be precise and clear to all stakeholders. I think what is missing at the moment is, and what Recital 77 clearly provides is, here's the vision, here's what we want to do, and the scope of the scheme needs to be clearly defined and matched to that. And we don't think it is like there is an option of having just one scheme, but there has always been this possibility of having using multiple options. For example, the first option was about encouraging and supporting soft measures to kind of enable this to happen, or to kind of have a EU-wide standard for the accreditation of the schemes that already exist. So this would mean that the existing schemes could apply for certification to a EU body. And yes, happy to discuss any of these issues either now or later in the cocktail break.
This is really your panel, right?
You are going to play
So many of the services, like web services and smartphone apps and so on, are developed by senior developers. So we are talking about a really long tail of development. And how would you prevent wiping out these small, innovative developers who will suddenly have to go through accreditations that potentially, if it's meaningful, it has to be done by someone else, by a third party. And as you see from other schemes like PCI, DSS, we are talking about like 100,000 euros and beyond, and then we do it after a certain time or when things change and so on. How does that fit to sort of this idea of the digital economy where everyone can sort of create its own business?
Yeah, I think that's a very valid point you make, because when you look at privacy seals, one of the advantages is that they provide a competitive and reputational advantage. So if I'm a really big company like Google, I may not need a privacy seal. But if I'm like a new company trying to enter the market, and I need to prove to like the consumers that I'm a reputable company, I might want to have a seal. Yes, I'm not sure.
I'm not actually sure that's true.
Yeah.
Because the users won't understand it, and in security seals you've seen that they actually, the guys who really got the seals were the big guys because they had the money and they just got it anyway. And then some really doubtful companies because they needed it. And the others who they had either no money or they used it otherwise. Like look at the guys from the panel that we had seen today from presenting some innovative privacy. None of them had any seals. They probably have the money.
Yeah, so when we looked at, I mean, there's a slight difference between the security seals that we looked at, and yes, in a way there is, there are players with the money to have, like not only one seal, but they can have multiple seals as well. They can pay for it, and they can go through very rigorous certification process. And I completely agree with you that they have to be, if there are fees, they have to be reasonable, because otherwise you're not going to get people subscribing to the scheme. Now, this is not meant to be. I don't think there is an element of that is like the GDPR does not intend to make it mandatory, at least in the sense that I understand it, for like everybody to go out and get one of these seals. But what it says is to encourage compliance, and because it provides individuals with a quick and easy means of kind of seeing something and verifying it, because we have established that nobody's got time to read privacy policies and stuff like that. So this is one of the means. It doesn't solve all the problems, and it's got a whole lot of other problems which, if you read our reports, I think you will kind of understand that it's not just a straightforward process, and one of the inhibitors is the cost. So.
Claudia.
Maybe an obvious question, but do you think this is actually possible to create a program that meets all the requirements that you formulated? And if so, what factors are relevant there to make it effective?
Yes, I think we would have to start. We would have to start with like the factors that have been identified. So this has all been presented to the Commission. The Commission is aware of it. As far as we are aware, it is feeding into the, we hope it is feeding into the discussions that are going on. And I think that if this scheme is established and it does not take into account some of these recommendations, it will fail, because we have seen that happen to other schemes. The other thing is we have seen that there is a lot of skepticism about this whole EU, EU privacy seal. So, I have my reservations about it, but I think it could work if we do it right, if we are clear about the objectives, we are clear about the scope, we specify exactly what it does and what it does not do, and what is supposed to be and what it is not supposed to be, because sometimes we forget what it is not supposed to be. So, and the final element is the public trust and communication. If that is not there, if the public doesn't see that as an added value, because it's going to fall flat like certain other schemes have done. And I think we should essentially learn lessons if we are going to do this at the EU-wide level, that we learn from the other EU-wide schemes that exist. And that's why we did this sectoral study, so that we learned lessons from these and we presented them. So then we went on to examine how it would work in probably the different areas like CCTV, biometrics, smart metering. And we spoke to like data protection authorities, we spoke to stakeholders, and then we even spoke to the smart metering industry group and different stakeholders. So in all, we have presented the Commission with the stuff that they need to make a decision on if they, what is the next step. So there are different options available. Well, I was trying to avoid using the term one size fits all. There is no one size fits all in data protection or privacy, I think, and we all agree with that. Or there will not be. This is not a silver bullet to fight everything, but I believe in it. I mean, it could work if it's done right. I mean, the CE marking worked.
She can't be stopped now. But I have the right. Okay, so a couple of lessons here. One. There are two lessons to be learned here. One, do research, do evidence-based stuff, and the second one is, well, that's what people here are doing, and I forgot the second one, so I'm taking off a beer, it will be quicker. Thank you all for being here.